Hi, this is Ahmed Aldhafeeri. I am a PhD student and currently I'm examining the public policy exception to the New York Convention on the Recognition and Enforcement of Arbitral Awards. Today I'm glad to share and present my current poster regarding a specific chapter on my thesis. The title of my poster, as shown, is Public Order and Enforcement of Foreign Arbitral Awards. But today I'm presenting the Saudi perspective, or the poster which is related to the Saudi perspective. Firstly, I would like to thank the Social Science and the Humanities Research Association for giving and allowing me to present my work today. In the International Conference on Business, Economics, Law, Language and Psychology, which will be held between 9th and 10th of March in Barcelona. As it has been indicated and can be seen, that I'm presenting public order, while some others prefer to call it public policy. And this exception is based on the New York Convention. So the New York Convention has been the most successful agreements in the field of international commercial arbitration. However, it was established in 1958, and some of its articles are now criticized for being outdated and difficult to apply. This is due to subsequent developments in international investment and arbitration. The convention contains some exceptions to the enforcement of arbitral awards, and hence arbitral awards may be refused by the competent authority. To illustrate the above, Article V2B of the Convention stipulates that recognition and enforcement of an arbitral award may be refused if the competent authority in the country where recognition and enforcement is sought finds that the award would be contrary to the public order or public policy of that country. Despite this stipulation, the Convention doesn't define public policy as a notion or term. This vagueness can lead to a broad interpretation of this notion. Moreover, can give an ultimate authority to the national courts to misuse this exception by it can give an ultimate authority to the national courts to misuse this exception by misusing this bar as a refusal ground. The public order exception to recognition and enforcement of international arbitral awards or foreign arbitral awards creates uncertainty with respect to enforcement of these awards, particularly because contracting states have diverse approaches to issues of public order. In this poster, briefly, I will look at recent global developments in the use of the public order exception. The notion of public order in the Saudi legal system is not definitive. In the last 2 decades, courts also haven't interpreted public policy narrowly in every case. The concept is still vague and subjective under Saudi law, judge have a considerable discretion on how to interpret and apply public order. One question can be asked is, what is public order or public policy? Frankly, if we revise the New York Convention, Article V, which is like public order, has been mentioned on this article. So Article 5 of the New York Convention on the recognition and enforcement of foreign arbitral awards, and also Article 36 of the Unistral Model Law, both provide and allow the state of recognition, both provide that a state may refuse to enforce an award if doing so would be contrary to the public policy or public order of the state in which enforcement is sought. Unfortunately, neither provides a definition of public order. It should be noted here, or worth mentioning, that in October 2015, the International Bar Association released a report in the public policy exception in the New York Convention that actually it's like an attempt to narrow the application of public policy. The importance or the significance of the research, there's no doubt that the enforcement of arbitral award is the main aim of the New York Convention, and it's the most crucial part of the process of enforcement of arbitral awards. However, by involving this term without any elaboration or explanation, the signatories render this convention less effective, and hence arbitration parties will be less confident about the efficiency of this convention and to what extent the signatories are adhere to apply its provisions. Therefore, the significance of this research based on clarifying public order exception and hence limit the ultimate authority of national courts to refuse enforcing foreign arbitral awards. Without doubt, this will increase the confidence of international community and dispute parties in Saudi's jurisdictions and New York Convention efficiency. Firstly, the research aims to examine the concept of public policy in Saudi Arabia and how did Saudi legislator identify public order. By this, the study seeks to conduct specific definition of public order. Secondly, since Sharia law plays a crucial role in Saudi's legal system, it will be crucial to find out Sharia effects on the on Saudi's public policy. Finally, this study seeks to investigate to what extent do arbitration law in Saudi Arabia comply with the New York Convention regarding public order. Regarding the results, it's hard to give a final result regarding this topic, but what I hope, like a potential result, it's to like identifying precisely the notion of public policy, and by doing so, the study seeks to clarify the nature of Saudi jurisdiction regarding public order, narrowing the ultimate authority of Saudi's courts, and promoting arbitration as a significant alternative dispute resolution method in the field of international commercial disputes. The questions I'm dealing with in this poster is the main question of the research is how is public policy interpreted in Saudi Arabia, and what are the sources of public policy in Saudi Arabia. Also, I aim to examine as a related question to my main question as follow: are the terms of public policy and Sharia in Saudi Arabia? Finally, do arbitration laws in Saudi Arabia comply with the New York Convention? Research methodology. As it can be noticed from modern legal research, which often depends on a combination of legal research methods to answer the research questions, the present research is no exception. As I mentioned before, this poster is like a part of a thesis. So the thesis relies on two key research methodologies. Firstly, legal doctrinal analysis, and secondly, a comparative methodology with a limited resort to an interview study. Doctrinal analysis is the traditional legal methodology. The role of the analytical approach is to study why a set of legal norms appears at first glance to be not clear or difficult to understand, as in, for example, the case of the arbitration laws of the GCC states. Analytical study always aims to bring about consistency and coherence by providing an in-depth analysis of those legal rules. The laws and legal norms are usually linked to certain legal principles which can be detected by studying the relevant laws. Therefore, the analysis of these laws leads to an evaluation of the compatibility of these laws with the relevant principle and is explained according to that framework. And then I would like thank you for your time, and I'm more than happy to receive your comments. You can find my email in this video. Thank you again very much, and I hope I can present like next time with actual results rather than potential. Thank you very much.